me, and I'm in the big black and white TV right. The Senate will please come to order. The Senate will please come to order. All those not having privileges of the floor will please vacate the chamber. With those on the floor and our guests in the gallery, please rise as we are led in prayer this morning by the Senator from Jefferson, and then please remain standing as we are led in the pledge this morning by the Senator from Cabell. Senator from Jefferson.
Thank you. Will you all please join me in prayer? Dear Lord, I want to thank you for this opportunity to serve you and to be here today. I ask you to please be with us in our proceedings. Help us to listen, to understand, to comprehend, and to discern your will. I ask you to please bless all of our leaders and elected officials, not just here, but local elected officials and national elected officials. May we all serve you with the goal of doing your will. Thank you. Please bless our veterans. Please bless our first responders. Please bless all of our West Virginia citizens. In Jesus' name, amen.
Amen. Senator from Cabell.
Please join me with the pledge. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. Reading of the Journal.
West Virginia Legislature, Senate Journal, Monday, October 1, 2018, pursuant to the adjournment of September 11, 2018.
The Senator from Morgan requests unanimous consent that further reading of the Journal be dispensed with and that it be approved as having been read. Is there objection? Chair hears none, so ordered. The hour having arrived for the Senate to sit as a court of impeachment, the Chair calls Acting Chief Justice Farrell to the chair.
Good morning. Without objection, the reading of the Court of Impeachment Journal is dispensed with, and the journal is approved as having been read. I'll note today that our deputy clerk is officiating. Lee's wife is having a child. I guess Lee is also having a child, so please keep them in your prayers as the miracle of birth occurs. Are we ready for our next witness? I need to have the marshal call the court to order. Mr. Marshal, please call the court to order.
All persons are commanded to keep silence on pain of imprisonment while the Senate is sitting as a court of impeachment.
I'll also note that we have one senator who wasn't here yesterday. Sir, you can get with the clerk and You may have stayed up all night watching on YouTube the proceedings so that you are comfortable in voting. I anticipate we will finish today according to the radio broadcast. We only have one witness today, but that's subject to change as always.
That's correct, Your Honor. Mike McCowan.
Mike McCowan, please.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? Please be seated.
You may proceed, sir.
Thank you, Your Honor. Good morning. Will you state your name, please?
Mike McCown.
And what is your current employment, Mr. McCown?
Currently employed with the State Auditor's Office.
And in what capacity are you employed?
I'm the Deputy State Auditor for Budget Analysis.
And prior to that employment, well, let me ask this question. How long have you been employed with the Auditor's Office?
Just a few months, since July.
And prior to that employment, what employment did you have?
I was the Director of the State Budget Office.
For how long, sir?
Almost 12 years.
Okay. I want to direct your attention. The primary focus of my questioning this morning is going to be the financial condition of the state over the last 5 or 6, 7 years. You've prepared, have you not, a chart that we've identified as Exhibit 137. Would you please put 137 up? And when you can see that on your screen, if you would, just explain what that reflects.
Yes, sir. That is a chart that I have prepared and I updated. This one goes back to FY12, runs through FY18, the year that we just finished. This was a chart that I would keep and update, keep it in my office. Just to keep the important part of this chart is the bottom line. This shows the ongoing base budgets for the general and lottery funds, which are the two biggest funds that the state has and the legislature has most of their discretion with their spending. And what this chart shows is from FY12 to 15, you see a good steady growth every year in our baseline budget. That means revenues were generally keeping pace with expenditures, and we were growing in normal mode. And then in FY15, you can see that the base budgets begin decreasing. That's because revenues became very stagnant, flat, and from about FY12, I think, through 17, I might be off a year there, but general revenue collections were basically flat, no growth. In normal years, those revenues would grow 3.5%.
Have you had an opportunity to examine as far performance in relation to expectations or projections over the past several years?
Performance of the revenues?
Yes, whether we hit revenue projections month to month.
We did not. In preparing for this, when I knew I was going to talk about this, I went back and looked at monthly collections, and something that I didn't realize was from April of 13 to November of 17, that's 4.5 years, we were never above estimate year to date in general revenue collections. It was constantly, we were in the red, swimming uphill. That was, I did not realize that never I don't think before, in all my time of being state government, 38
For what
years.
purpose does the senator rise?
Point of order, the people in the back cannot hear the witness at all. Thank you.
Please adjust the microphones.
I'm sorry, is that good?
I think that works better. Let's backtrack then, just so they can pick up. As you indicated, this chart basically shows base budgets from fiscal year 12 through fiscal year 18, correct?
It does, and it shows FY 12 through 15 where base budgets grew. This is just, we're talking general and lottery funds, the funds that legislature has the most discretion over and can generally be used for just about anything that you want to spend it on. And then from 15 to 18, you see declines in base budgets. I don't think, base budgets normally grow 3.5% a year in an average year. So we were stagnant from FY 15 to 18, actually decreasing budgets because we started developing huge budget gaps and what we call structural budget gaps. Revenues were not keeping pace with the expenditures. We had Medicaid and PEIA, both healthcare related growth every year, just about. Those tended to grow 6 to 8% a year. Revenues were not keeping pace. We were not meeting estimate. As I was just saying, from April of 13 through November of 17, we were never out of the red year to date on our revenue collections. We were always in the red. So we were swimming up water trying to catch. We did mid-year budget cuts for 5 straight years, FY 13, 14, 15, 16, and 17. 5 years in a row, we had to do mid-year budget cuts. It was tough.
Let me refer you to the last column so we can get an explanation. It appears that you are attempting to differentiate fiscal year 15 when the growth in the budget ceased from fiscal year 18, is that correct?
Yes, because we peaked in FY 15 on our base budgets. We started showing those in presentations. The legislature realized that, the governor realized that, and they started making structural cuts to our budgets to allow the revenues to catch up. FY 18, we're in pretty good shape, so actually the cuts that we made 16, 17, and 18, we've actually gotten budget back structurally balanced now.
You have 3 items on that last column encompassed in a square. What does that signify?
Those are the major categories on the 6-year plan that we use. Only those that I boxed in were the only 3 that had growth. You can see all the others were from 15 to 18. All the others categories were reduced.
So, for instance, with respect to the legislature, from 15 to 18, there was a 4.1% decrease in the amount of the budget for that entity.
For those 4 years, yes, sir.
And the Supreme Court actually received a 7.5% increase during that same period, is that correct?
Yes, sir.
And other than that, it was PEIA and Medicaid were the only areas that were increased.
PEIA, healthcare, Medicaid, healthcare. Yeah, healthcare related. Yes, sir.
You mentioned a series of mid-year budget cuts. Was one of those budget cuts in November of 2016?
Yes, sir.
Let me ask if you would present the witness with Exhibit 134, please. You got it in front of you. Can you tell the members of the Senate what that represents? What that?
This was the we did it in November. Governor Tomlin. Again, Governor Tomlin, when he was here, this was November 17. That's at the end of that 4.5-year period where we were in the red constantly. He, if I recall correctly, wanted to do as much as he could on the way out We knew they were going to be, again, have a bad year in FY17, or yes, 17. This is November 16, I'm sorry. It's right in the middle of that 4.5-year period. This totals $59 million. It was just his way of trying to leave things in somewhat manageable order on his way out the door.
And is the significance of a mid-year budget cut that agencies that had planned on a certain amount of money to spend over the full fiscal year had to reduce that based on the amount of the cut? Is that fair to say?
Yes, sir. And this one, if I recall, most agencies took a 2% cut, which when you're almost halfway through the year is, computes out to closer to 3 or 4%. The bulk of these cuts, of the $59 million, almost $60 million, Medicaid took a $25 million cut, I think, and the school aid formula took over an $11 million cut. Those were the two major reductions in that year. But you can see from this list, almost all agencies took about 2% cut.
With respect to the exhibit, there's a cabinet, there's several columns, 3 columns. There's a cabinet name, then there's a breakout from that cabinet or department, and then there's a total of that particular agency, correct?
Yes, sir.
And you identified to me that there was, when this chart was reproduced, one entity or one entry that had been, I guess when it was compressed, missed. Can you tell us what that was?
When I looked at this, I did not prepare this. But I looked at it in the first page, right under DMAPS, Military Affairs and Public Safety, right under the Adjutant General. It looks like the corrections got cut off. That cut to Division of Corrections was $3.75 million.
So if that were in there, then the other entries would add up to that $5.963 million.
Yes, sir.
That DMAPS took to total.
Yes,
Is that
sir.
correct?
Yes, sir.
And you said you didn't prepare this chart. You have had an opportunity to review it and compare it with the information available to you. Is that fair to say?
Yes, sir.
And the information in here, other than the omission of Department of Corrections, is correct? Is that
That's correct.
So, for instance, if we were interested in the HEPC, Higher Education Policy Commission cuts, we could determine on the second page exactly how much each higher education institution or under that community and technical college was cut as a result of this mid-year cut. Is that fair to say?
Yes, sir. And those look like straight 2% cuts.
So, for instance, if you were interested in Marshall, you'd see that it was $1.24 million cut. For WVU, it would be a $2.634 million cut. Is that correct?
Yes, sir.
Now, following the mid-year budget cuts, there was, and I think all of us here remember, a budget passed by the legislature that went before the governor, and he symbolically vetoed it. You recall that?
I do.
And I won't get into the symbolism of that action, but that was followed by a special session that was extensive. Fair to say?
Yes, sir.
And at the end of that session, did the legislature pass a budget?
They did.
And did it go into effect without the governor's signature?
It did.
Did that budget include substantial cuts for fiscal year 18?
It did. Many of these mid-year cuts were carried over into that budget. Public ed, I think, the total was cut about $22 million from the previous year's base budget. Higher ed was cut almost $20 million. We did there's a long list of items that were reduced. Some things I can remember, $5 million was cut from the institution lines in the health facilities. I think $3 million was cut from tobacco education and DHHR. The RESAs were eliminated. That was the year the funding for the RESAs were eliminated. FY18 was a difficult time.
And when we say fiscal year 18, that's July 1 of 17?
Started July 1 of 17. That was Governor Justice's first budget.
And that would continue through the following June 30, correct?
That's correct.
There were, in the past, hiring freezes instituted. Can you tell us what you know about the continuation of that process?
Yeah, those have been in effect for many years. I know going back to at least Governor Manchin, perhaps even Governor Wise. But yes, there was, during all this time, there was a hiring freeze in place.
Overall, if you were asked to describe the period between the start of fiscal year 15 and through the fiscal year 18, how would you describe financial times during that period?
Those were difficult times. We were in constant looking for dollars. I know the legislature, along with the governor, we would go into special revenue accounts and sweep cash to help balance budgets, not only with mid-year cuts, but we also balance budgets by sweeping special revenue accounts. We used rainy day to balance the budget. FY 15, 16, and 17. That had never been done before. The rainy day fund was established in 1994, and it had only been used for floods and emergency type of expenditures up until FY 15, and then for 3 years in a row. FY 15 we used $100 million of rainy day to balance the budget. FY 16 we used $98 million, and FY 17 we used $131 million. Those that, along with all these other remedies that we would use, budget cuts, mid-year budget cuts, sweeping cash accounts. We've swept reappropriated balances from, I know, the Senate. We used a lot of their reappropriated balances to balance 1 year. Anything we could think of.
Going back to the mid-year budget cut in November of 2016, I didn't see listed on the agencies affected the Supreme Court. Was there budget cut?
Was not.
Thank you. Thank you, Mr. McCown. That's all I have. Council Ross?
Yes, sir. Mr. McCown, my name is Mike Hissam. I represent Justice Walker. You're not here today to offer any specific testimony about Beth Walker, are you?
No, sir. Just the facts.
And if someone, well, let's focus on that, for example. The exhibit that you showed about the mid-year cut, that occurred before Justice Walker took office. Is that right? Well, let me help you out.
Sure
she took office on January 1st, 2017.
This happened in November 16.
Okay. And if someone took office on January 1st, 2017, what fiscal year was that?
January 1st of 17?
Right.
FY 17.
Okay. Thank you.
Are there any questions? Any written questions? Seeing none, does the House have another witness? Sir, you are excused. The House is rested.
No, Your Honor, our witness was Beth Walker who testified yesterday. The respondent was Beth Walker in arrest.
All right. Our party is arrested. Senator?
Yes, Your Honor. I can't hear your microphone through the headphones.
How's that? Okay. Both sides have rested. That means you have heard all the evidence that's going to be presented in this case. At this point, under the rules, we will have closing statements for the House managers prepared at this time. You may proceed, sir. I'll explain also that the House having the burden has the right to open. There will be then Justice Walker's counsel, and then the House manager will close. Turn that around. I hear myself being repeated.
Mr. Justice, members of the Senate, common sense. Common sense. When I heard those two words from our state auditor yesterday, it was like a bolt of lightning. As those of you who are lawyers know, and those of you who aren't lawyers probably suspect this, but oftentimes we who are lawyers, and I thought I was retired a few years ago, but no such luck. Those of us who are lawyers sometimes get tunnel vision when we're looking at facts. We're looking for a statute or a regulation or something that gives us a firm and direct answer to our question. And sometimes common sense gets lost in that effort. You know, throughout the state of West Virginia, today and other days, there are state employees who, in order to do their duty, will work through lunch, might even work late into the night, all without any expectation of the taxpayers paying for a lunch when they finally get a few minutes to take a lunch. Those of our judiciary who are actually out in the trenches do the same thing. They may hear a case that is in trial, it carries over into the lunch hour. They may have time to grab a sandwich. They may not, but never with any type of expectation that the taxpayers are going to pay for them for a lunch. And you can bet that the Supreme Court has not allocated a single penny for those judges, for those magistrates to have lunch on those days when they're forced by their schedule and their duties to work through lunch or perhaps even into the late night hours. And as Auditor McCuskey observed yesterday, if that were the case, if our taxpayers were expected to pay lunch for every public employee, every member of the judiciary who worked through lunch, either as a matter of efficiency or a matter of convenience to the litigants, the cost would be out of sight. So this issue of the paid working lunches is really a common sense issue as much as it is a legal issue. And frankly, it just doesn't pass the smell test. If you examine the reason that this practice started, and let me start with Exhibit 85. And hopefully I'll have better luck with technology today than I did yesterday. I'm beginning to develop an allergy for technology. Exhibit 85 is a letter from the Judicial Investigation Commission, the chairperson, Ronald Wilson, who's the judge and chairman, addressed to Justice Walker. And if you look at the last page of that letter, the last indented paragraph, he offers a reason for this practice. He states, however, as stated in one of the court's recent responses to a request under the Freedom of Information Act, the court has in recent years chosen to remain on the bench without a lunch break until all arguments are concluded, and as a convenience to litigants and lawyers. Thereafter, a working lunch allows the court to finish consideration of the cases and other administrative matters. And he concludes that paragraph by saying, thus, I believe that court-provided lunches benefited the public by enabling the court to continue and complete its work promptly. That apparently is the reason that was given for these lunch. So the question is this really a reflection of a noble purpose? The purpose being to avoid inconvenience to litigants and benefit the public? Or is it more or less a thinly disguised excuse for a free taxpayer-paid lunch? And I think the answer was revealed after this abuse was discovered. And I mentioned when we started this process, timing is everything. Timing and context. Timing. When did the public receive information about this practice? When was the sunshine, the best disinfectant, shown upon this practice? And that was after the FOIA request in December of 2017, the request made by Kenny Branch. And so if you go then to Exhibit 73, this provides the answer to that question as whether this was a noble purpose or just an excuse. Exhibit 73 is a letter to Auditor McCuskey from Barbara Allen, the Court Administrative Director. And if you look at the last page, the second and last page of that last full paragraph, she says, as you probably know from the media reports to which you allude in your letter, the issue of working lunches is now moot inasmuch as the court has ceased the practice. So in other words, there are no more working lunches. The court takes a lunch break, as it always has, and the litigants are again inconvenienced. If there were a noble purpose, I suggest to you, they would continue the working lunches but not ask you or the other taxpayers to pay for it. They would kick in, like so many of us do here when we work through lunch and we send someone out. We all kick in a little something. In our Judiciary Committee room, we have a little bucket that says snack contributions, and we use that. People kick in. We go, if we need a sandwich or we need a snack, we send out and we get it. We take it from the snack bucket. If there was a noble purpose here, that's exactly what the Supreme Court would be doing. If they really didn't want to inconvenience the litigants, they would continue working through the arguments and then take their break, but not ask you or the taxpayers to pay for it. If you examine this issue even further, the argument that they make is that it was limited to days when litigants were there for argument. But they also took lunches, if you look at the exhibits, on days when they met to discuss administrative matters. Thus, no litigants were present on those days, just members of the court. Among the documents that you have, and we did produce, I think, 5 full notebooks for those of you who prefer hard copies, and when you deliberate, you'll have those available. If you look through those, you'll see that there are examples of administrative minutes that reflect what actually goes on in those proceedings, and there are no litigants present. There's no one that's being inconvenienced. It's the judges who are being convenienced by having the taxpayers pay for lunches on those days. For example, if you would pull up Exhibit D from Justice Walker's exhibits, and this has been referred to as the day on which Justice Walker voted against recommended merit pay raises for about 60 employees, many of whom were among the lower paid of the staff, and many of whom had not had a raise for over 7 years. Almost paradoxically, this is the same day that the justices were treated to lunch from Soho's at a cost of approximately $17.31. And you can confirm that fact by looking at the chart that we prepared about the lunches, which is available to you as Exhibit 174. So the administrative conferences are not excused by the explanation that they were there, they were done, those working lunches were done on those days to avoid inconvenience to the litigants, because there were no litigants there. Another thing that you can, if you fully investigate this so-called free working lunch thing, is you can discover by looking at the receipts, and those receipts are all included in the documents at Exhibit 125 for your review. And if you took the time to look at them, and let me refer to one of those. If you would you get Exhibit 125 and put up Walker 55 is at the bottom of that. That would be 55, and at the top it shows House 000448. We're just going to take one of these receipts, otherwise it would take us a long, long time. But I want to point out a few things. You are at that document. It's a one-page document. At the bottom it says Walker 55. I'm sorry, 55. And at the top it's House 000448. That's it. Well, just display the document if you can. If you can get the full page on there, that would be fine. That's good enough. Thank you. All right, if you look at that document, you will see several things. This is a form that's filled out to confirm the expenditure by P card of money for working lunches. You'll see on the left-hand side a list of the, for instance, the sponsor, which is Mr. Garnes, who we've heard his name mentioned. The location of the function is the Justice's Chamber. The date, which is 9/13/17, that's September of 17. You'll see the total that was spent that day, $171. You'll see the purpose down below that, the conference. And I'll note, if you would look at the court schedule that we've admitted previously, you'll see that is a date that was scheduled for oral argument. You'll see the list of attendees, which includes Justice Walker. Significantly, for some reason, Justice Davis is not included. You'll see some other names on there that were mentioned the other day. C. Garnes, which is Chris Garnes, who was the person who presented the P card. Jay Gundy, who's the security man, and as you heard yesterday, neither of those people are actually involved in the decision of the argument that was made on the case that was presented. Mr. Garnes essentially is the person sent out to bring the meal back. You will see on the right-hand side a copy, which was attached to the form, of the receipt from the Block Restaurant and Wine Cellar. And if you'll go down a few lines, you'll see the date, which is November 13th, and significantly you will see the time that the meal was picked up, 11/31/46. Now, why that is significant, if you'll remember, the testimony was that the judges would work through the lunch hour and complete the docket that day before breaking for lunch. If you take the time to go through all of these exhibits, you'll see that almost in every case, the lunch was picked up before the lunch hour, so it could be delivered, presumably, at the lunch hour. Also significantly, it raises a question when you have one of the justices absent from the conference, whether or not any meaningful discussion can actually take place during that lunch about the case when one of the members who is assigned to decide it does not appear. I'll let you do your own analysis of that. Also, let's remember that this was not just a meal. It wasn't just a Big Mac. It wasn't just a hot dog. These meals were ordered in and paid for by the taxpayers from upscale restaurants throughout the area. If you'll look at Exhibit 124, I'm not going to go completely through this, just to remind you what it's about. This is the exhibit that was prepared by the legislative auditor, who did an analysis of each of these lunches and listed by date, restaurant, number of attendees, the total cost, and average per person cost. As I said, if you'll look through this list, you'll see these are not fast food places. You won't see any receipts from the cafeteria located conveniently just underneath us, basically. They are upscale restaurants like South Hills, Soho's, Paterno's, The Block, and some of these amounts actually exceed $20 a person for lunch, which the taxpayers, as I indicated, many times have paid for. Most of those meals were clearly in excess of the recommended guidelines, GSA guidelines, which were adopted by the Supreme Court in its own travel policies, as was confirmed yesterday by one of the witnesses that we offered here during the end of the day, who is the CFO of Sue Racer Troy, who was the CFO, essentially the CFO of the Supreme Court. No legitimate reason has been offered as to why these lunches should exceed those guidelines. And keep in mind, those guidelines apply to meals that are received while on travel. These meals were taken while here in the Capitol, but no legitimate reason has been offered why they should be exempted from those same guidelines. As hard as I tried, I was unable to get Justice Walker to admit that there was anything wrong with this practice. The best I could get from her was that it was not illegal. Consistently, she used that term, it's not illegal. Now, I will concede to each of you that we as a legislature have not expressly adopted a statute that says you get $136,000 salary and absolutely no free lunches. Perhaps we were naive in not assuming that the Supreme Court would be so arrogant as to think that they were entitled to free lunches when they were doing their jobs. But there is no statute. I would argue with you that anyone who analyzed our constitutional provision, which vests in us the ability to set a limit on salaries, and West Virginia Code Section 51-1-10A, where we actually set that salary at $136,000, anybody who looked at those two provisions would have been concerned that anything over and above that would violate the spirit, if not the letter, of the law. And our position is that it's not only illegal, it's unethical under the provisions of the Ethics Act, which the legislature has passed, which prohibits using a public office for private gain. Now, there may be some issue, although it hasn't been raised here today, whether the Ethics Act applies to everyone in state government except the Supreme Court, but I would suggest to you, and I read to the witness, to Justice Walker, the preamble to the West Virginia Code of Judicial Conduct, which the court itself has adopted, which states in paragraph 3, the West Virginia Code of Judicial Conduct establishes standards for the ethical conduct of judges and judicial candidates, and it is not intended as an exhaustive guide for the conduct of judges and judicial candidates who are governed in their judicial and personal conduct by general ethical standards as well as the code. Isn't it logical for any thoughtful person to conclude that the Ethics Act, which governs all of us and every public employee, would constitute a general standard, general ethical standard, as contemplated by that code section? So I think that what we've done in this short trial is expose for everyone, not just you all, but the public who's paying attention, what a scam this practice was. Unfortunately, although Justice Walker testified in relation to the firing of Steve Canterbury, that she knew within 2 days of taking office that there were problems with the HR policy, she apparently was not seriously concerned about this free lunch policy. That's disappointing. She continued practicing, or participating in the practice through October 31st of 2017, and didn't participate in November because she had to leave town and be out of town. Only after she learned of the FOIA request that was made on December 5th by Kenny Bass, and that is in your materials at Exhibit 104, is the extensive Freedom of Information request Mr. Bass filed, which includes on paragraph 3 any and all charges for meals purchased using public funds for the justices and clerks during 2016 and 17. So only after that request was made and transmitted among the justices did Justice Walker seek to repay for the lunches that she and her assistant had received. If you'll look at Exhibit O, if you wouldn't mind putting Exhibit O up, please. Exhibit O is an email from Justice Walker to Sue Troy, and basically it says, when you complete a calculation of the court's spending on meals brought in to the Capitol for the justices and their staffs in 2017 and before, that information is shared in response to a FOIA request. Can you share that information with us? Assuming it is permissible from a legal accounting perspective, I will be writing the court a personal check for 1/5 of the total, which she did do toward the end of that month. But it was significant to her to make sure that was done before the information was provided in connection with the FOIA request. And as I suggested in my opening statement, one of my favorite statements is the true measure of a character is what you do when no one's looking. And now we see someone was looking. One other thing I just want to comment on that kind of burnt me up at the time it occurred was this effort by the JIC, the Judicial Investigation Commission, its press release that occurred during the midst of the investigation that was undertaken by the House Judiciary Committee. That is Exhibit 106. Exhibit 106. And I want to highlight for you what appears to be the fifth paragraph in that press release. This was a press release that was issued and disseminated among the media and appeared all throughout the state. And I'm going to read to you that paragraph because I think there's some interesting inconsistencies in that paragraph. It states, JIC policy is not to acknowledge the existence of complaints against judicial officers until probable cause has been found to issue a statement of charges or an admonishment. I'll stop there for a minute. In other words, no one is supposed to know there's actually been a charge filed if that policy is adhered to. Then it goes on to read, we are taking the unusual step of making our findings public in these cases because the Supreme Court justices are the highest judicial officers in West Virginia. It is important for the public to know that allegations against them have been thoroughly investigated and that they have been cleared of wrongdoing. Now think about that for a minute. The first sentence says it's our policy not to tell anybody we've opened a file and are investigating. So if they followed that policy, no one would know to begin with. The second and third sentences basically says we're taking this unusual step. I use the word, I think, unprecedented step. That we're going to tell you about something you didn't know about because we closed the investigation on them and cleared them of wrongdoing. Does that make any sense at all? Does that make any sense? You should know about it, but we want to be sure you know we've closed the file. I'll let you draw your own conclusion as to the timing and the intent of that particular press release. I'm not going to say a whole lot about the contracted legal opinion. It's not a lot of money, $10,000, but as an attorney and someone who voted for Justice Walker as a candidate, it was very disappointing to me that someone who most people think when they vote for is elected to hear cases and write decisions. I mean, if you ask the average person, isn't that what they would think these Supreme Court justices do? Apparently there was a shortage of staff, something most of us have experienced one time or another. But in most cases, don't we just buckle down and do it ourselves? Don't we work long hours into the night, maybe even on the weekend, to get the job done? If you look at the invoice that was produced from the clerk who prepared this, from the contractor who prepared this, you'll see the bulk of the work was done during the Memorial Day weekend. And if you compare that with the court's calendar, you'll find that the court was closed the entire week. There was nothing scheduled. Let me put it that way. There was nothing scheduled on the court's calendar that entire week of Memorial Day. And if you would analyze the number of hours that this particular person took to do the work, and you subtracted from that travel time and the time that she actually consulted with Justice Walker, you would find it works out to be in somewhere between 50 and 60 hours, which in a lump sum would certainly seem like a lot, but scattered over the Memorial Day week is manageable for anybody who's really willing to work hard, and more importantly, someone who's really interested in saving the taxpayers' money. I want to talk a minute about the renovations. I know that there's been a lot of talk about that, and we produced a number of different exhibits about those renovations. The purpose of our testimony today was to put that in perspective, the timing of that in perspective. It was not to suggest that Justice Walker had anything to do with the revenue shortfalls that we were experiencing, but it was to provide context within which decisions were made that have to be questioned, decisions to spend money that elsewhere in the state folks were being asked to tighten their belt. We have Mr. McCowan discussed for you Exhibit 134. I'm not going to go through that in detail. That was a analysis of the mid-year cuts that were made in November of 2016. As he indicated, a mid-year cut of 2% really has a greater effect than that because it's halfway through the budget year. You can actually go into this chart and, if you wish, see how much your local higher education institution or school board, your local education institute had to feel the pain. But I know most of you felt that pain individually when you had to hear from your school board members or your local colleges about how that hurt. You lived that cut. That's part of the context of this. Keep in mind, as Mr. McCowan said, things weren't so bad leading up to about 2015, but after that became pretty bleak, and nearly everyone was asked to sacrifice. Nearly everyone except the Supreme Court, who went along their merry spending ways. That's important context to judge the expenditure of $130,000 to renovate an office that had only 6 years earlier had been renovated to the tune of about $265,000. Also, it's important to remember that if you look at the invoices that make up those expenses, and those invoices are available in several different places. Exhibit 54 in your binders have a good summary, and then each individual invoice that you can look at. Exhibits 129 and 130 actually have pictures of some of the items which were purchased. And let me ask, let's go to that. Exhibit number 130, would you please put that up? Exhibit number 130 is a multi-page exhibit, and the significance of it, this is plumbing fixtures that went into the private bathroom of the office assigned to Justice Walker. You'll see that there were fixtures totaling $3,260. It does not include that mirror that appears in one of the pictures that was $724.50, but if you look on the second page, you'll see a picture of the faucet, the fancy faucet that went in, which was about $418. This is the kind of information that's available if you want to get into that. It gives you a sense of the cosmetic nature of a lot of the changes that were made to this office that was, by all accounts, functional at the time Justice Benjamin left it. He had certainly utilized it for 6 years, at least 6 years. The restroom facility apparently was adequate for his uses, in spite of the fact that there were 2 faucets instead of 1. Horrors. These changes were cosmetic. They weren't functional. They were cosmetic. They were done essentially for the benefit of one person, not for the benefit of your constituents. Not something you would be doing if you were concerned about the pain that your constituents were feeling as a result of all these cuts. Not something you would continue on if you were concerned about the various cuts that had been made to the budget in the 2018 year. The drastic cuts to higher education, to public education, to all the various agencies. Not something that you would do if you were sincerely interested in retaining the trust of the public in your branch of government. There was a question posed yesterday that caused me to think a little bit last night and interrupt what little sleep I got, and that was reference to Article 3, Section 20 of the Bill of Rights of our Constitution, which is titled Preservation of Free Government. And it states, free government and the blessings of liberty can be preserved to any people only by a firm adherence to justice, moderation, temperance, frugality, and virtue, and by frequent recurrence to fundamental principles. That caused me to reflect on how in the world we got to where we are today, when one branch of government seems to be infected by an atmosphere of entitlement, cavalier indifference to the protection and expenditure of public funds. How could such an atmosphere have been created? How have we come so far from that statement of purpose in the Bill of Rights? One would think, would one not think, that a salary of $136,000 a year, eligibility to participate in a very generous pension program, which I think most of you know is one of our best funded programs, and 4 months of vacation, one would think that would be enough, but somehow it wasn't. I don't get it. I invited Justice Walker to basically set the standard for this process when I referred her yesterday to 2 of the cases that were in our materials that were involving disciplinary proceedings against attorneys. And I asked her whether or not the standard that had been set, and I hope you remember this, those cases are in the materials. I asked her, if that's the standard for the typical attorney, would you expect that the standard for judicial officers for ethical violations would be any less? Would you hold them accountable to the same standards? And she basically said yes. And those standards are really a 3-part test. What steps are appropriate to punish for a violation? And in this case, apparently, Justice Walker is suggesting to you that a sincere apology, and I don't doubt her apology is sincere, and offering to repay for the lunches should be sufficient punishment, along with having to endure what's an embarrassing trial. You may think so. I noted when she was asked by one of your questions whether she was willing to repay for all the excessive spending on her office, the answer was no. The second test, the second question that's asked is whether the discipline imposed is adequate to serve as an effective deterrent to other judges. That's the second question that needs to be asked. And finally, and maybe most importantly, whether the discipline is adequate to restore public confidence in the ethical standards of the judiciary. Those are the three tests, and basically Justice Walker agreed that was an appropriate test to apply in this case. I began my remarks and my opening statement to you with a quote from James Monroe, which I still think is very pertinent. In that quote, he basically analogizes or explains the reason for the impeachment process in that the legislature basically, and here's his language, occupies that ground which the people themselves would occupy. And that through the legislature, as occupying the place of the people, the whole movement will be controlled and every branch made subservient to their will, meaning the will of the people. Today, this is the people's ground. You occupy it for the people. They can't hold Justice Walker accountable for another 10 years. For another 10 years, and only then if she decides to run again. But today, and for them, and only today, you can hold her accountable. Thank you.
Counsel for Justice Walker.
Thank you, Mr. Chief Justice. May it please the court. And to the members of the Court of Impeachment, thank you. You have paid careful attention during this trial. You have listened to the witness's testimony and paid close attention to the documents. There's been a lot of criticism of this body. There's even been lawsuits filed suggesting that this is a runaway jury, an overly political process, a kangaroo court. We don't agree with that. We have faced this body because we think this is the proper forum. It's the forum in our Constitution for judging whether a constitutional officer can be removed from office. And I think it's significant that Chairman Schott invites you to judge Beth Walker, but he never actually vocalizes the request. He never puts in words what he asks you to do with your vote. He asks you to vote to remove a constitutional officer elected by the people of this state from office. That's what we're here to do. And this is a historic occasion, and this is very much a situation that is unique. There haven't been these trials. There isn't a standard to apply. And because of that, we think the easiest thing to do is to, as I said in the opening, talk about the facts. And that's what we're here to do this morning. I want to start with the timeline. The simple fact that Beth Walker took office on January 1st, 2017. Now, we've heard an awful lot about other justices and other events and policies and procedures and perhaps misconduct that occurred before that point. But you're here to consider January 1st, 2017 to the present. We focus on that with respect to many issues, including the lunches. And we focus on what happened in that time period. What was brought to Beth's attention? What was put on her radar? What did she do in response? Chairman Schott agreed yesterday in his opening statement that Beth didn't cause this environment, but that she was quick to join the party. I would submit to you that this was no party she joined. You can see that from her testimony. You can see that from the emails. This was more like a dysfunctional family that she joined. And like many dysfunctional families, they didn't always get along. She raised her concerns. She got into arguments with the other justices. She voted against what they were going to do, and she was a single lone justice in the minority. She was never Chief Justice. They wouldn't let her be Chief Justice. And who were the other people in this family that were responsible for how the court functioned? Well, they were the administrative directors. For a long time, that was Steve Canterbury. He only overlapped with Beth for about 2 days, 3 days tops. Then there was Gary Johnson. There were in-house lawyers. There had been many other Chief Justices. Until Alan Lawfrey took over as Chief Justice and they announced this new 4-year term, the Chief Justice had rotated every year. But you didn't hear from any of those other Chief Justices. The House managers didn't call the administrative directors, not the current one, not Mr. Johnson, not Mr. Canterbury. They didn't call any of the in-house lawyers who were responsible for the policies or procedures. So what did you learn about, what we did learn about the organization was Beth made an analogy to a corporation. She said the Supreme Court's like a board of directors. The Chief Justice is like the CEO. The administrative director is like the COO, the Chief Operating Officer. And I would submit to you that it was kind of like a small, privately held family business because there were a lot of disputes, and it was a dysfunctional family. And despite all of those problems, Beth wanted to be Chief Justice. But what happened when she wanted to be? She was told by her colleagues she didn't have enough experience, that she didn't have the institutional memory that they had on the court. Well, we would suggest to you that those years of experience are part of the problem. The long time service on the Supreme Court, all of this time spent in state government, didn't help the people who were in charge of the court run it efficiently. It didn't help them run it like a business, which is what Beth wanted to do. We see this quite clearly on the issue of raises. Beth resisted their raises. I'm not going to bring them up to you. Our exhibits are very simple. You can look at them. They're online. We only have 27 exhibits. But look at Exhibit C. That's on the May meeting when she resisted the raises in the administrative conference. She was outvoted. 3 days later, the issue comes back. This is in Exhibit D. Again, she's outvoted. She states her concern. There are 5 of them. They're listed out in the minutes of the meeting. Look at Exhibit D. Look at page 2. Look at what she said. The last reason for her resistance to these raises, quote, the state's current financial circumstances. She wasn't ignoring that situation. She wasn't ignoring what Chairman Schott calls the context. She was saying, we shouldn't do this. And then look at the exhibit. The exhibit to that document has a list of the raises. And you can look for it yourself, and you can look at what kind of raises that the court, led by Chief Justice Workman, wanted to give. I look at an individual employee where she proposes a $13,000 raise, a $4,000 raise. 2 on the next page at $7,800. 1 with a raise of $31,000. Beth voted against all of these raises, and they still went into effect. And why did that happen? Because she was outvoted. The issue of raises shows why Beth supports a constitutional amendment. She supports the constitutional amendment that's on the ballot this fall to wrest control over the budget with this body, with the legislature. She will support that, and she absolutely is aware of the painful budget cuts that have existed in this state. And she is certainly aware of the fact that the body that sets the budget, that should also include control over the Supreme Court. I do want to talk a minute about Justice Benjamin's office, which Chairman Schott says by all accounts was functioning, except for the fact that it didn't have proper lighting to work, it didn't have a desk, it didn't have an office chair, it didn't have a writing surface except for this bizarre Ernest Hemingway globe table that no one could actually work around. And we reject as a premise that no work needed done to the Justice's office. These are important places. They may not be accessed by the general public who can just wander in, but they are important places where important work is done. Every federal and state court in the country, including every appellate court, invest money in the areas where the justices and their law clerks work. And she was trying to build a chamber that would fit within the Capitol and last for the 12 years she was going to be there, including the 10 remaining, and after her occupant, the next occupant, was in that office. She wasn't going to take any of the furniture with her. And let's go through, on Justice Benjamin's office, Exhibit 135. You saw this up on the screen yesterday. There's a section called Furniture and Decor with items listed in red that show the items that Justice Benjamin took with him. Almost $12,000 worth of just 3 armchairs that cost $12,000 are presumably in his home now. An office chair, a desk, a cabinet, an ottoman. You heard Beth testify that there are other items that aren't in red that cost some significant money, $3,600 to reupholster a sofa. It wasn't in there either. You saw the pictures for yourself. Where is this stuff? And while we're looking at these documents, we heard yesterday about this Silling and Associates, and you heard the legislative auditor's representative, Justin Robinson, try to suggest that, well, maybe these Silling and Associates bills had something to do with Justice Walker. But when my colleague came up here, Mr. Ritchie, and asked him, he admitted, well, that's not quite right. Because if you look at the legislative auditor's report, and this is Exhibit 102, page 10, you see that Silling billed a total of $374. And in fact, there's a footnote that there was only one charge for $450 for work on Justice, $450 for work done on Justice Walker's chambers, and we know exactly what that was for. So it's not unexplained. If you read this section of the legislative auditor's report, you will find that there is $370,000, and by process of elimination, it belongs to Justice Benjamin's office and Justice Workman's office. And there's not been any explanation of that. There hasn't been any explanation of that. But it doesn't belong to Justice Walker. And for that matter, where is Justice Benjamin? The House managers subpoenaed him to be here this morning at 9 a.m. Did they release him from his subpoena? Where's Mr. Canterbury? What concern did they have about what you were going to hear about their conduct, about their testimony, about the lack of things that Beth Walker did? You can only draw the conclusion that they didn't have any fire to bring against Beth Walker and her conduct in office. Let's be clear, though. There does need to be oversight by the legislature of Justice's office renovations. There needs to be a master plan. There needs to be the constitutional amendment. There needs to be something to ensure that what we have over there in Justice Davis's office doesn't happen again, and that we have a coherent Cass-Gilbert design for this beautiful and historic building. It's clear that the justices ought not be able to run off with their furniture, and that there ought to be some oversight, and Beth supports that. Well, let's talk briefly about the lunches, although Chairman Schott talked about it for quite some time. Beth stopped paying the lunches because it wasn't right. You heard her say that. Chairman Schott just said that he couldn't get Beth Walker to admit it was wrong. That is simply not the case. You heard her express her regret. You heard her say that it's not appropriate. If you doubt that, go back and watch the video of her testimony. And let's also be quite clear. The taxpayers aren't out one dime for Beth Walker's lunches. She paid the money back, and she's the only one to do so. And we heard this thing about the Judicial Investigation Commission, the JIC. Beth Walker didn't control the JIC. We're not here to judge them, and she didn't control whether or not they made that press release. She didn't write that press release. We're not here to talk about the JIC or Judge Wilson's conduct in charge of the JIC. We are here to talk about Beth Walker. We heard all of this mention of fast food places and GSA per diem lunches. Why does that matter? Beth Walker agrees that the lunches weren't appropriate, and she paid the money back. She agrees that the policy against lunches ought to be enshrined in court policy for the whole court system. But can she impose that policy herself? You heard Sue Troy yesterday testify. No, it doesn't work that way. She's never, in 6 years, seen a justice set a policy by herself. So let's look at Article 14, the article in front of you, and let's look at the lettered paragraphs, A through G. Ask yourself, at the end of Mr. Schott's closing statement, at the end of this brief trial, what have you heard about Beth Walker in paragraphs A through G? Paragraph A is travel policies prior to October 2016. You didn't hear anything about Beth Walker on that because she wasn't on the court then. Paragraph B is the reporting of taxable fringe benefits on W-2s. You didn't hear anything about Beth Walker's involvement with that. Paragraph C is auditing estate purchasing cards. What did Sue Troy testify to? She wasn't involved. Beth wasn't involved in purchasing card. Paragraph D, home office policies. Did Beth have a home office? No. Was she involved in home office policies? No. Paragraph E, state automobiles. Did Beth use a state automobile? Did she check it out? No. Paragraph F, inventories of state property. Wasn't involved in that issue. Paragraph G, purchasing procedures and containment methods. She wasn't involved in that issue. She was a lone justice who was never given the opportunity to be chief. She couldn't implement policies on her own. These are the House manager's articles. This is their case. These are their allegations. What did they show you to prove paragraphs A through G against Beth Walker? Instead, we've heard about basically 4 areas. Lunches, occupying the vast majority of Chairman Schott's time this morning, were paid back. Office renovations. Chairman Schott didn't devote much time to that. We've explained that issue to you. On both of these, Beth has testified. You heard her herself. She's sat down here, she's embraced this process, she has faced this body, and she told you that what she did was wrong. She made mistakes. She tried to fix those mistakes. She regrets them. The third issue is the one-time hiring of a temporary law clerk. I'm not going to spend a lot of time on this. I respect Chairman Schott greatly, but he's never served as a law clerk. He's never had to write a judicial opinion, to the best of my knowledge. It is hard and difficult work. I've done it for 2 different federal judges. It takes time. It's a collaborative process. It's important to establish the rule of law and communicate with the parties and the court. Policies and procedures is the last issue. And I submit to you that that's really what is being directed at in paragraphs A through G of Article 14. But as we just discussed, you haven't heard testimony against Beth Walker on those issues. Really focus on what the standard is that you're being asked to apply. Chairman Schott has mentioned these lawyer discipline cases. Well, there's 2 problems with that. Number 1, she hasn't been disciplined by the bar. We're a self-regulating profession, just like doctors and dentists and pharmacists. We regulate ourselves through the Office of Disciplinary Counsel and the Supreme Court. She hasn't been imposed, and no one has seriously suggested that she committed any violation of the rules of professional conduct. Second problem with that theory, it's not in the Constitution. It's not in the Constitution as the standard for the removal of a public office holder. As a judge, Beth Walker has lived by the text of that document and the text of the United States Constitution. Let's do that here. Rather than import some procedure from lawyer discipline that doesn't belong here, let's all live by the Constitution. And that's the standard that is set. It is not what we heard yesterday out of Mr. Robinson's mouth, best practices. We aren't imposing that standard on a public office holder. You won't find the phrase best practices in the West Virginia Constitution. Think instead about Beth's conduct in office. What has Chairman Schott acknowledged about Beth's conduct there? What has he acknowledged about her good deeds? Has he admitted her efforts to save the state money, her attempts at the Supreme Court to right the ship? Think about what you heard from Sue Racer Troy on this issue of drug court and P-cards being used to purchase gift cards. I walked up here and I asked Ms. Troy, did I hear you right? What happened? There was a concern raised by the auditor. You didn't hear Ms. Kaufman ask the auditor about this, but Ms. Troy testified there was a concern raised by the auditor, number 1. Number 2, Beth expressed her concern. And number 3, for once, she finally prevailed on her colleagues to stop that practice. That's the pattern that you see of Beth's conduct and behavior. It matches with what you heard out of her own mouth in her testimony yesterday. Think about what I said in my opening. She is human. She made mistakes. Think about the timeline here of January through the summer when she wasn't there and there were no lunches being provided and these issues, to November when her husband drove himself to the emergency room with a heart attack and had surgery and she had to recover. Think about that timeline and how she comported herself in that time in office. Did she make mistakes? Sure. She's told you she did. She regrets them. She's expressed her remorse. But we're really talking about a time period of about 9 months. And think about your first 9 months in any job. Think about your first 9 months in this job. She was trying to learn the job. She was trying to right the ship. She was trying to improve things. She still thinks there's more work to be done. That's why she supports this constitutional amendment. But she hasn't done anything under the text, under the Constitution, to justify her removal from office. Thank you.
Mr. Schott, rebuttal.
Mr. Justice, members of the Court of Impeachment, I would agree with Mr. Hissom on one thing. Look at the documents. Take some time to look at the documents. But when you look at them, pay close attention to the date on which the document reflects the action or the matter was taken. As I said, probably too much for you to bear. What's important is what happened, what someone did before anyone was looking, because so much of what's happened here is a result of the inquiries made by the press, the publicity that flowed from that. What did Justice Walker do before people were watching? Regarding the articles of impeachment, conveniently, Mr. Hissom has overlooked the first paragraph of those articles. Keep in mind, those articles were drafted to encompass all of the justices, and it reflects a variety of activities, but most importantly, the first paragraph talks about reckless, lavish spending. It refers to renovations of offices, the meals, all of that's in the first paragraph. And you've heard multiple evidence of activities that reflect in that first paragraph. I can't help but think that this defense reminds me of my golf game, and I apologize to the female members of the Senate because men always tend to analogize to some kind of sports analogy. I am a golfer in the loosest term. I play no more than twice a year, and although I've been playing for many years, twice a year, I have to think, and the people that play with me agree, I'm basically a beginner. I play because I like to get outside and I like to be with my friends. And when you have friends that know they can beat the tar out of you, you often have many friends. So I do play occasionally. I am in many respects a rookie. And my strategy when I play now is to negotiate as many mulligans as I can get. And those of you who don't play golf, a mulligan is simply a do-over. You make a bad shot. In my case, I hit a tee shot, the ball dribbles off the end of the tee, maybe luckily gets to the women's tee. I ask for a mulligan. Typically, even among friends, you get one mulligan on the front nine and one mulligan on the back nine, and that's it. Not me. I have managed to negotiate as many as 5 mulligans. And that's why this reminds me of my golf game. Here we go. I'm sorry. At a time when public education is feeling the pain of a nearly $13 million cut, I got sucked into the working lunch scam and only stopped when I was about to be caught. Don't worry. You're a beginner. Take a mulligan. But, you know, at a time when higher education was feeling the pain of a nearly $7 million cut, I spent $10 million of taxpayer money to farm out something that I could have and should have been able to do myself. It's okay. Take another mulligan. But I'm really sorry that at a time when cuts to the 2018 budget cost public education $22.7 million, higher education over $19 million, public employee retirement system over $12 million, PEIA nearly $13 million, I'm sorry that I spent $130,000 of taxpayer money to an office that had been thoroughly renovated just 6 years earlier at a cost at that time of nearly $265,000 and which was functional for my use. No problem. Take another mulligan. How many mulligans does she get? How many mulligans does she want? And more importantly, how many mulligans do you think the people that you represent think she deserves? When I was here before you on September 14th to submit a proposal, I said to you that I thought there was some benefit to allowing 2 of our justices to continue. I meant that. I think there is some benefit. But with every benefit, a cost accompanies that. There's a cost-benefit analysis that has to be made, and you all will be making that analysis. If the ultimate goal is to show some degree of mercy, then obviously the decision is easy. If the ultimate goal is to assure that public trust is restored in our judicial branch, then there's 3 questions that I would suggest you ask yourself. Question number 1, has the public lost trust in the Supreme Court? I would suggest to you, if you were asking me based on what I'm hearing from my constituents, what I'm reading in the paper, that's an easy answer. It's almost a rhetorical question. In some cases, the confidence has not just been lost, it's been shattered. And unfortunately, there are a lot of victims of that, a lot of victims. This is a sad situation. One group of victims is actually the members of the judiciary themselves, other than the 5 Supreme Court justices. They're collateral damage. They're the people in the trenches working every day who don't have an expectation of special treatment, who don't have money to throw around on frivolous cosmetic changes to their office. Those folks have been affected. They are indeed collateral damage. Second question, if you believe the answer to the first question is yes, has Justice Walker's performance, while no one was looking, contributed to that? And finally, if the answer is yes, will keeping her on the court for 10 more years help or harm efforts to reconstruct that trust and confidence? It all boils down to this. If you believe that Justice Walker's performance while no one was looking satisfies you and satisfies the confidence that was placed in her by the voters who elected her to this special position, if retaining her on the bench for 10 more years will help restore that trust, then by all means, reject this article of impeachment, by all means. On the other hand, if based on what your constituents have told you and what you believe after hearing the evidence, you doubt that retaining on Justice Walker on the bench for 10 more years will help restore the trust and confidence of the public, then you should vote to sustain this article of impeachment. Thank you.
Thank you. Thank you, counsel. Both sides are very professional, and I thank them for their work in this case. I'll note under Rule 26, one of your members, was not present yesterday. He has represented to the chair that he did view the proceedings online, and I request the Senate President to determine his eligibility to participate in deliberations and voting in this matter. Rule 31 requires that 2/3 of you would vote in the affirmative to impeach Justice Walker. If there is less than 2/3 of those elected, which is 23, then the amendment or the article of impeachment shall be rejected. Under Rule 32 of the Rules of Impeachment, at this time I'll entertain a motion for the Senate to dissolve into the Court of Impeachment to begin deliberations. Do I hear such a motion? Senator from Cabell moves. Everybody in favor, please vote yes. Those vote no. This is to dissolve into the Court of Impeachment. It's a roll call vote. Please vote. Clerk will prepare the machine. While the clerk prepares the machine, I'll ask counsel to ensure that the clerk's office has your cell phone numbers and locations so that the clerk can notify you when they return with a deliberate date. Has everybody voted? If so, the clerk will close the machine, ascertain the results. On that question, 28 yeas, 5 noes. I declare the Court of Impeachment now dissolved into conference. I'll ask the Sergeant of Arms to clear the chamber of all people who are not members, including the galleries. I'll ask the clerk to secure all audio equipment so that no recording is made outside the presence. And I'll ask the Senate President to resume the chair and take charge of the deliberations. You got his hammer, you got his gavel.
We may be coming back to Supreme Court sometime here in a little bit, but I'm not sure. I guess go back to regular programming for now. Okie dokie. Thanks, sir.